your patience. This is the family law docket B for March 7th, 2023. My name is Patricia Fassett. Any other strikes, setovers, or quick matters?
Judge, I have the Cook and Hagdahl. That's just a presentation for Your Honor. I do know that Ms. Hagdahl provided some objections, but I still think that it would be relatively quick.
Yes. And there, okay.
And so, Your Honor, after receiving Ms. Hagdahl's objections, I did make some of her requested changes. So you should have an amended proposed order that was filed on the 24th.
Says February 22.
I think that one should have a signature of 23.
The parenting plan says February 23, but that's still not the right one.
Make sure it was filed on the 24th. It should say 23. You're right.
Okay, and the child support order, your signature line says February 22 on that. The other one says 23, and then the parenting plan says 23, and the temporary family law order is dated the 22nd. So that's what I have.
Correct.
If we can work off those.
Yeah, that's fine. Okay. I didn't submit any other revisions aside from the parenting plan. So all of the other orders that you have in front of you, aside from the old parenting plan, you can work off of.
Okay. All right. So I did see the declaration with the objections. So it'd probably be easier to just work through those. And then you can let me know what you've agreed to and changed and what we need to talk about. So there's a reference to the retroactive child support. And so the request was that child support be retroactive to 4/21/22.
Correct, Your Honor. And this matter was filed in November of 22. In her initial request, she had requested November of 22 for a start date. My motion, which was brought before the court on my client's behalf, was filed in January. So it's our request to have January to current.
Right. Ms. Hagdahl.
I'm not sure what I'm supposed to say at this point.
If you have any other comments other than what you've outlined in your objections.
So I was unaware of the RCW that I put into the objection when I went and filed the parenting plan. So I was unaware that I was able to request this for that time frame. I thought I was only allowed to request at the time of when I filed the parenting plan.
All right, here's what I'm going to do. I'm going to start support January 2023, but what I'm going to do is reserve on any retroactive support for trial. So that means that you can ask as part of the trial, the court to consider additional payments for that time period that you're requesting.
Okay.
I think that was it, at least that I saw with regard to the child support order.
All right. And then, so I'm going to, if that's the only thing, then I'll sign that one and move it out of the way. Then it looks like you're objecting to limitations
On daycare,
That it
nanny, and healthcare, because since our separation, our child has had 28 doctor's appointments in 10 months. He has seen 20 specialists. 14 of those appointments have been made in 2022, none of which the respondent has shown up for. He has been made aware of all of these appointments. For 2023, we're 66 days into the year. Our child has had 14 other doctor's appointments with specialists for his needs. And the respondent has only been able to show up for 4 of those appointments. Our child has at least 4 more referrals out to specialists. I have a list of all 20 of the specialists he has seen between Progress Center, OHSU Dornbeckers, Peace Health Clinic and Legacy Salmon Creek.
So, Your Honor, I think she's getting at the uninsured medical expenses in the child support order. Correct, she can correct me if I'm wrong, but that's what I'm kind of gathering, and I did include proportionate shares pursuant to the statute in my child support order.
No, I'm discussing about medical decisions based off the fact that the respondent has not been a part of all of these medical appointments for our child, and I've been the sole caregiver for this.
Okay, and I would just note, Your Honor, did order joint decision making at the last hearing. I believe my order is indicative of that.
Yes, so generally speaking, Ms. Hegdahl, there's if there's no allegations of concerns of abandonment or what we call 191, because that's the statute that it's in, 191 issues. That's 2609 191, abandonment, child abuse, neglect, domestic violence, sex offenses, those types of issues alleged. There's no reason to limit decision making of a parent. That does not put you in a position where if there's an emergency that you have to call him and wait for a response to act on getting any help for your child.
He doesn't have any visitation or rights to his minor daughter from a previous relationship, though.
And I would just object, that's beyond the scope
That
of this
doesn't have
hearing.
anything to do with this.
Okay.
All right, so I'm going to leave that part as it is. Second objection is decision making. So again, no joint decision making because of your 80% residential time, and you object to him having. Okay, I guess we dealt with that. Third objection, paragraph 6, dispute resolution. You're requesting mediation instead of going to court. Is that correct?
Yes.
Okay. Any response, Ms. Bliss?
And my standard is always just to go to court. I'll defer to the court if you think that mediation would be helpful or appropriate. I just typically find when having pro se litigants involved, it's kind of counterproductive at that point.
I think I'm going to leave it where it's at, go to court. I'm just concerned that there's some animosity in this case, and it may not be beneficial for the parties to try to work things out in that manner. I'm more than happy to reconsider that, but at this point I'm going to leave it at go to court.
This next objection was a scrivener's error on my part, and my new order did reflect that change.
Okay, so under section 8, Ms. Hegdahl, it now says children under school age are scheduled to live with Cassandra, except when they're scheduled to live with Jeremy. So that has been remedied. Paragraph 8, school schedule, section other.
So there's quite a bit here. I think I could tell you I did make the change to the time in Ms. Hegdahl's proposal. She just wrote all day or didn't include specific times. Apparently my specific times that I included weren't appropriate to her. So I did go ahead and make her 9 a.m. to 6 p.m. time change. I think the remainder of that section of it not being clear and concise enough, I would disagree. I think it's very clear whether it's a school day or non-school day is the same versus weekday or weekend. And then at the end, father shall provide his schedule within 3 days of receipt. That was the order of the court. So I think that that's appropriate.
All right, so Ms. Hegdahl, hopefully you've seen the changes that are made, but essentially it says under the other, it says 1 to 2 overnights per week to coincide with father's day off of work, dependent upon whether his days off are on a school day or a non-school day. 1 overnight on school days and 2 overnights on non-school days. On school days, father will pick the child up after school and return them to school the following day. Non-school days, father will pick the child up by 9 a.m., return them the following day at 6 p.m.
So is Sunday considered a school day because he goes into school the next day, or is it just Monday, Tuesday, Wednesday, Thursday, Friday? That's what I'm trying to get at, because
Because it's a school.
yeah, it's a school night, so.
Whomever
like,
is sitting with you
Sunday-
and talking needs to not do that. If you were in court, you wouldn't be allowed to have somebody that's not an attorney sitting next to you feeding you information. So please ask them to stop doing that. Ms. Bliss,
I think I think at least from my perspective, it's obvious that if a child is going into a school, so a Sunday night going into a Monday, then that's considered a school night. So that's if we want to add specific language in there that says if it's occurring on a Sunday into a Monday, then that's considered a school day. I just don't think that that's necessary to include.
Absolutely,
what's that?
absolutely. I want the language in there where it's very clear and concise on what is detailed a school night.
All right, so if Ms. Bliss, if you're suggesting Sunday would be considered a school day, and pickup is after school, what time on Sunday? So if this is a Sunday, what time would pickup be? Either party have any?
I think, Your Honor, I can probably revise this language to say that if a Sunday is the day in which they're having visitation, that the 9 a.m. time still applies, and then he'll just take the child to school the next morning instead of at 6 p.m. I think that resolves the issue.
All right, so Ms. Hegdahl, what I did is I included on school days, father will pick the child up after school, return them to school the following day. If the overnight visit is on a Sunday, pickup is at 9 a.m. and drop off at school on Monday morning. So then you would pick up the child Monday after school.
Okay, and if our child doesn't have school, when do I get to pick up our child? Would it be pick up at 9 a.m. that next day?
If it's a non-school day, it would be 6 p.m. according to the what's been suggested.
Okay,
Does that work for you?
I think so.
Okay, so if it's a Sunday and there's a Monday holiday, it would be 9 a.m. Sunday morning to 6 p.m. Sunday evening.
Okay. I did have an issue with the holiday and summer schedule in a couple spots too in this.
Okay.
The father gets 1 week uninterrupted time. How come I don't have that for myself as well, so that me and my other child can do family vacations of 1 week uninterrupted summer vacation time?
And Your Honor, I would just say that that wasn't discussed at the hearing. The only thing that was discussed was my proposal that father have that. Additionally, mother does have primary custody of this child, has several times, I'm sure, throughout the month of week-long periods to which she doesn't have any interruptions. But mainly it wasn't discussed at the hearing, so I didn't include it.
I'm gonna include that in the order. So mother shall also have 1 week uninterrupted vacation time with the same in writing by May 15th notice to father, so you don't have any conflicts.
Okay.
I also have another discrepancy in the holiday summer schedule. So the winter break is not what Miss Bliss has proposed, is not my winter break. Winter break on my proposed parenting plan is the father gets our child on odd years.
Okay, one moment.
But she does have the Christmas Eve and day part right.
So Your Honor, there was a little bit of confusion here because she had a mid-winter break, a winter break, and a Christmas Eve day and a New Year's Eve day schedule. I condensed it to a Christmas Eve day winter break schedule to include the standard one parent gets one half of the break, the other parent gets the second half of the break, because I'm looking in her objections and her proposals, and that's the most sense I could make of it.
Okay, so right now, Ms. Hegdahl, it reads, every year, mother shall have the child from the day school releases until 12:24 at 6 p.m. and father shall have the child from 12:24 at 6 p.m. to the day school resumes, with the exception of New Year's Day Eve listed below. And I know that, I believe I initially adopted Ms. Bliss's proposed vacation schedule, a holiday schedule, and then
No,
changed it to adopt yours. So what are you requesting?
Well, you had changed it to be my schedule. And so my schedule had that I have our son Christmas Eve every year. He goes to his father's house every year for Christmas. And then on odd years for what's considered winter break is when he gets to spend time with his father. So whatever the school has listed as winter break, if it's from like December 18th through, then he gets them through that time frame. And then I get our child for Christmas Eve, then give them back for Christmas.
Okay, so if I'm understanding you correctly, you're suggesting that odd years, Mr. Cook get the child the entirety of the winter break, but for Christmas Eve, which would go to you. And then even years, you would have the entire winter break, but for Christmas Day, which he would get every year. Okay.
Yeah, and then I would have the New Year's and New Year's Eve and New Year's Day.
Okay. Ms. Bliss?
I think we're getting really into the weeds. Christmas is 10 months away. This is a temporary order. I don't really have a preference one way or the other. I think mine provides both parents equal time every single year instead of one parent one year, one parent the next, but I'll defer to the court.
So Ms. Hegdahl, what I'm gonna leave it the way Ms. Bliss is proposing. It does split up the winter break a little bit, and you would start the winter break and end the winter break with the child. With what I'm gonna do though is I'm gonna change it from the day school releases. And I'm gonna change it until 12:25 at 9 a.m. and then father gets the child until New Year's Eve at 9 a.m. until school goes back. So just give me a second to change that.
I think in my review, the only other issue in this section was Thanksgiving, 6 p.m. versus 8 p.m. Again, I don't really have a preference. I feel like on Thanksgiving, dinners may go past 6 p.m. Obviously, the intention is to have dinner with the parent, but I'm not going to fight over 2 hours, so I'll let Your Honor make that decision.
Okay, let me get back
It's
to.
the time frame for 6 p.m. is only set because our son goes to bed between 6 and 7:30 at night. So it's just with his normal schedule routine that it's been like that for the last several months. So I was just trying to keep his schedule consistent.
Well, I'm going to split the difference and we'll make it 7 p.m.
Okay.
And it looks like the last one is second to last one. Telephone media access.
I don't understand what is appropriate for a 15-month-old who is nonverbal with language delays on what this is considered to be appropriate. I don't feel like it's worded right for our child and his developmental delays and age. So I don't know what is expected.
Ms. Bliss?
I mean, this is just my standard language for telephone. If we want to put, I just don't want to pigeonhole, because again, this is a temporary order. Best case scenario, this lasts well beyond this child's, first, second, third year, all the way into his teenage years. Obviously that's optimistic, but the intention is there. I don't want to pigeonhole to a 5-minute conversation. I think liberal and reasonable. I think each parent can work on that. And if it becomes an issue down the road, we can bring it back for clarification.
I'm bringing it up now because it's already been an issue for the last 10 months since we've been separated, which is why I'm asking for clear and concise language.
And I don't have that information. That wasn't provided at the hearing. So if Your Honor wants to make specific language here, that's fine.
So here's what I'm going to do. And because there's no language that I think that's going to really resolve any potential issues that may arise, I would hope that the parties aren't phoning the child when the child's with the other parent, just to take away time from the other parent, especially if we're talking about a 15-month-old that isn't verbal at this point. So I'm going to just strike the liberal and in B1, non-residential parent shall have telephone contact with the child. I'm going to leave section 2 the same, because I think the child should always have the ability to contact the parent that they're not with during their residential time. If there's additional issues that arise, or if it's being misused, then by all means it can be raised at this point. But I haven't heard of that being an issue. But consider this a warning that the parties shouldn't misuse telephone access to take away time from the other parent. Last objection is proportionate costs, and I think Ms. Bliss, you indicated you already fixed that. Is that correct?
I corrected, well, no, I have the uninsured medical expenses already included in the child support order. Ms. Hegdahl seems to be requesting daycare expenses and childcare expenses. I didn't include that. A, it wasn't requested at the hearing, but B, the court imputed her at a significantly lower income with the consideration based on her arguments that daycare is too expensive, that's why she's not working. I think obviously if she wants to return to work, then daycare is appropriate, but I think that that's a issue for a later hearing, not current before the court.
All right, anything from you, Ms. Hegdahl?
I just wanted the daycare cost language included in for when it is an appropriate time, when our child is finished with all of his specialists and therapies, and I can find the appropriate childcare for our special needs child for me to return back to work. But until then, I have to be able to focus on all of his care and needs with all these specialists. So I can't not show up to work to be there for my child and his appointments. So I want to be prepared for when he makes that milestone to have safe childcare, that I can make that determination and submit a resume, get daycare taken care of, and go with the career that I want to go with. I don't want to have to keep coming back and forth to court to make amendments to this. I just want to get it taken care of right away.
Well, this is a temporary order, so I'm going to leave the language as is for now. The hope would be that we get a final order in place, and the final order would be able to encompass all of those possible things that will show up in the future. But at this point, the proportional share has been entered, and so I'll enter that order with that change.
Thank you, Judge.
All right, thank you. Good luck. Okay. Any other cases, or I'm just going to start at the top and move down the list?
Judge, I'll take one that I promise you will be quick.
Okay.
That's Hitchcock and Hitchcock number 6. Review of discovery answers from Mr. Hitchcock.
Yes, 21-300-35808.
And we did get some of his answers, although not entirely complete, but for purposes of today, what we do need, Mr. Hitchcock, just actual pay stubs, bank statements, and the W-2 from 2022.
Hold on. Go slow. Write these down.
Pay stubs, bank statements.
I gave you my
W-2.
I gave you my W-2. I gave you my most recent bank statement, and I've given you all of my pay stubs. Well, I've given you my year. What?
I guess we can file what we have, Your Honor, then, and set this out for 2 weeks if you want to review it. It just needs to go away. We just need that honed in a little bit. We got some earning type information, but I wouldn't call that a pay stub. It's rather just kind of shows, it looks like it was even maybe self-prepared. Didn't get the W-2 from 20.
Hey,
Mr. Hitchcock, Do not interrupt, please.
Okay, I will take my rebuttal time when I get it.
Thanks. I appreciate it. Mr. Zandy, go ahead.
So actual pay stubs, and the W-2 from 22, and I didn't see any bank statements. If it's in there, I can relook, but I didn't see any. And then just a roughed out value for what he thinks the properties are worth. And I think that's what we need.
So that's what you're still waiting for?
Yep.
Okay. Mr. Hitchcock. You're muted. You're muted, so you would need to unmute so I can hear you.
All right. Yeah, I've given all my pay stubs to Chad. I find it very offensive that he says that they look like they're self-prepared. It is 2023. I don't get pay stubs. It's all online. I've taken shots of that. I don't get paper pay stubs. I've given you every pay stub I have, Chad. I mean, I didn't give you every pay stub. I've given you year to dates for the end ones. So you have the most recent. You have the total incomes that I've earned, like for the past 3 years. What we do not have is any pay stubs for Megan Hitchcock. It has been 20 months since we filed for divorce. It has been 2 years and 5 months since we unofficially separated, and we have no pay stubs from Megan Hitchcock. We have no financials from Megan Hitchcock. We have nothing from Megan Hitchcock.
Yeah, so we're reviewing the motion to compel for Mr. Hitchcock. There hasn't been any formal request for discovery from my client. We get that. I will certainly prepare that and get that out, but that's well beyond what we're here today for.
Your Honor, when we first came for temporary orders, there was a disclosure of income. Megan did not disclose that she was working for Spectrum. She made herself sound like a hapless victim that couldn't find work because she had previously been a stay-at-home mom when she was already working for her high-paying job. So just the basis of going to temporary orders to start with, there has been a neglect, a denial, and lying of what's going on. I request that we get pay stubs and financials from Megan because she's hiding that.
Mr. Zandy, when there was, I don't know if you've been counsel record for Ms. Hitchcock this entire case. I know that Mr. Hitchcock was previously represented. And it appears as though those requests were made 2 years ago, December of 2021.
Chad was the lawyer at the time.
Yeah, I've been involved since the beginning, Judge. I think Mr. Hitchcock's gone through 2 attorneys off the top of my head that I can think of, maybe 3.
Does that have anything to do with scope, Chad? Two attorneys.
Okay. This isn't a buddy pal Chad situation, so he can be Mr. Zandy, and I'm calling you Mr. Hitchcock. I'm not calling you Mark.
Okay.
We're in
Thank
a
you.
court. This is Zoom, I understand, but this is a courtroom.
I do oppose that this has any scope about what's going on.
Well, we're here to review a motion in order to compel that was filed by Mr. Zandy.
Yes.
I don't
and
have any motions filed by you recently if there's ongoing discovery concerns on your behalf.
But you did say, Your Honor, that, I mean, she should have at least started with her financials to begin with. One.
Well, and I don't know if that's something that your previous attorney still has and can turn over to you.
No, Megan has hidden that she was working for Spectrum.
Okay, well, then you need to make a formal request for discovery. If you need to ask for a motion to compel, you need to ask for a motion to compel. You're representing yourself, and I have to hold you to the same standards as I would if you were represented. So I can't give you legal advice, but I can tell you that certain things need to happen in order for the court to make a ruling on something.
Yeah, Your Honor, I did give Mr. Zandy all the pay stubs of every money I've earned. There will be some income that I have not earned, but that's going to come forward. But then he asked for bank statements, and I gave him my most recent bank statements. So he's asking for every bank statement for the last year, and that's going to include like my minute purchases of where I purchase things and where I go out to eat. I don't feel like that's appropriate.
Well, the only thing I can tell you is that's standard. So that's a common request that is very often complied with in its entirety.
How do I get bank statements for every month? That's like pages after pages after pages.
For your bank records? That's, I mean, I know how I would get mine, but I don't know how you're gonna get yours.
Well,
Hold on, Mr. Hitchcock. Mr. Zandy, what exactly are you missing? So I'm still unclear.
If we had the bank statements, that would go a long way. What we're trying to do is match up the incomes. He has switched jobs. I believe it was during the course of last year. So it would be nice to trace the incomes. Most notably, how you do that is through the complete pay stubs, match that up with the bank statements and the tax returns. And those are the three things you got that kind of clarifies any income dispute. So that's what we need it for. And I do that in probably 90% of my divorce cases, as I think is pretty common practice. So that's why we need that. And that's why we only went back for a year and not 3 or 5 years like some other folks do on this docket. Just to not try to be unreasonable, just want to be able to move this case along. We can't do that until we can certify that the discovery is complete. And at this point, we just can't do that.
Okay.
I don't want to come back. I just want the information so that I can rest on that and we can go to a mediation or a trial and we have everything and not have to have any holes with that.
Okay, knowing why he's requesting that, is there any concern that you can get that provided to Mr. Zandy in a timely fashion, Mr. Hitchcock?
Yeah, I'm really unsure about the whole thing. But yeah, I mean, I can, and Mr. Zandy, you're welcome to email me. And I will be doing those motions for your client, but you're welcome to email me any questions you have. Yeah, like I said, I can be direct with you. I can be transparent with you, Mr. Zandy.
All right, so here's where we're at. I'm going to expect that the bank statements for a 1-year period will be provided. Sounds like pay stubs, according to Mr. Hitchcock, have been provided. And if there's any tax returns that have not been provided, need to be provided.
And I did tell Mr. Zandy that I haven't filed taxes and it's been like 3 years. I'd have to work with Megan to file, and that's been very difficult.
And do you have any documentation about extensions or anything of that nature?
No, we always get money back, so there's no big deal with extensions. Like, they don't ever penalize you if they're giving you money back, which we've always filed late, never this late. But once again, like, I mean, Megan doesn't. I ask her about the kids' school and she doesn't answer me. I ask her about anything and she just doesn't respond to anything.
Well, I'm sorry to hear that. That's not before me. The only thing that I've got any history in this case for is this discovery request that came last month, or excuse me, in January. So
I would need help and documents from Megan's side to file. And
okay, well, it sounds like you know what Mr. Zandy needs. You know why he needs it now. I'm going to expect that you're going to get those to him in a timely fashion, and you'll work with him to get those done. And if there's any other issues, it can be brought back before the court. And then I'm assuming I'll see you again on your motion, Mr. Hitchcock.
Yep.
All right. Thank you.
Maintenance.
Thank you.
A debt that was ordered to be paid by the respondent, as well as an issue that was slightly more collateral, closing an account that had some money in it. I can inform the court that after our last hearing, my client was able to confirm that the $2,200 was paid for the remainder of the maintenance. So that was received. We are still wishing to proceed on the contempt, however, most notably on the non-payment of the car and the concerns my client has that this is intended to be a continued concern for Mr. Monday on non-payment of the maintenance. I'll inform the court that we're dealing with an order that the court made in a hearing in January of this year. The Respondent was ordered to pay maintenance in the amount of $2,500 that included $1,500 he had previously been paying towards community debt, the residence, home equity line of credit, and that's related to the home, the primary residence that was a shared asset of the marital community, and an additional $1,000 of maintenance for the discrepancy in the income of the parties and the length of the marriage, as well as the financial need of my client. We can see from record what my client is concerned is a pattern of conduct or behavior whereby Mr. Monday is essentially voluntarily underemploying himself to be in a position where he doesn't have to pay these obligations. Between the pay stubs that were submitted and bank records that were submitted by Mr. Monday, in November, he had income from his employment in the amount of right around $7,000. 6,861 was deposited into a bank account. And each pay stub that was provided, an additional $50 a check was put into a different bank account. There were 5 checks because he's paid weekly in that month. 4,200 in the month of December, 5,400 in the month of January, before going all the way down to about $3,700 in the month of February. The court can see from the pay stubs provided and the bank records a change in the financial status right around the court hearing. The last paycheck on the 20th of January, prior to the court hearing, or for work prior to the court hearing, was a paycheck of $1,800. The week before, $1,400. The week before, $1,347. After the hearing was a paycheck of $702, $1,000, $899, $801, $813. A substantial reduction in pay that coincides with the court hearing and not medical concerns as stated by Mr. Monday. Materials provided showed that going back to 2021 and possibly even before, there were some medical issues for Mr. Monday and a series of medications or doctor's notes limiting his hours, some in 2021 and several starting in January of 2023. However, during that period of time of the longstanding issue, the significantly increased net paychecks and pay are evident. Again, November, December, and January, just from what was provided, show about $1,300 or so a month on average, as opposed to an average since the last court hearing of about $890. So he's making about $400 less as of the time of the court hearing, ordering him to pay this every week. And it is not a coincidence. In the month of January, also on the bank records provided, Mr. Monday took out $945 at ATMs, spent $130 at the liquor store on January 11th, $55 on January 22nd, $50, $46 at a tobacco shop January 26th, $215 at a spa on January 8th. For $445, while my client is concerned about being able to pay the mortgage and in a position where she has to come to court and ask for a contempt before he actually pays. The court is supposed to look to whether or not the violation is willful or they have the ability to functionally pay. And I think here there's ample evidence that that is the case. Mr. Monday, during the time that my client was emailing and texting him from the records provided in her declaration, about both his payment to the truck that is in her name as well and for maintenance, was more focused on trying to get the firearms from the residence, and from the email contact had scheduled with a mover to come and pick up the safe. Now, there's no discussion in his declaration about the cost of that, but if that's a cost he's able to pay instead of pay the maintenance, that's significantly concerning to my client and I think would be to the court. He also in his declaration indicated that, or suggested my client was in some way driving up fees as a result of this because of her concern about the checking account that was closed that had some money in it. My client's declaration, I think, shows and establishes there was money in the account. She had seen a transfer pending for more that was regularly how money would be provided from one account to the other. And then that was closed. She was texting him to get the money back and he didn't provide it. Instead, he was, according to his declaration, meeting with his attorney to try and work out an offer at a period of time where he was not paying her the maintenance support ordered, or even enough to cover the bills as he had for the months prior at the time of separation. I believe this is a situation where it's relatively straightforward. He has ultimately paid, but that does not mean that he was not able to pay at the time. It shows or suggests that he was or would be able. What strikes as fairly voluntary underemployment now to produce lower pay stubs despite 15 or so paychecks that we have some indication of prior, where he regularly made $1,200-$1,300 a week on average, is significant, especially in light of his claims that this back issue is somewhat longstanding. I think the next concern or next issue, the relief my client's asking for civil sanctions, attorney's fees for having to bring the action. She had to file in court to get him to pay. Payment wasn't made until after she's got him served. And it was the threat of court that made him pay. That the court effectively modified was the temporary order on property. Your Honor had indicated that firearms be transported to Mr. Monday. Those are important to him very clearly, but my client is concerned that those assets might be one of the only assets that she has available to ensure that the bills are able to be paid. We presented in my client's initial declaration a statement about the value of the firearms. We're asking the court allow those to be order them to be transferred to my client's name so that they can be sold or disposed of. That half the money as a community asset go to her directly, and that the other half be held in trust to pay any failures on the part of Mr. Monday to meet the obligations the court set out for him. Given that my client's concern, she also asked the court to order that his half of the tax return be put into trust for the same purpose. She has concerns that he's basically trying to drive up fees and force her to go through court so that she's not able to pay for her own attorney. He makes a statement in his text message to her when she's asking about paying the bills, paying the car, paying the maintenance, paying the money that was in the account that he closed. The quicker we get divorced, the quicker you'll get what you want. At the same time, he's trying to negotiate with his attorney to make an offer, knowing that she was not financially able to meet her obligations. That shows not just willfulness, but intent to put her in a position where she's somewhat compelled to take what he thinks is a reasonable or fair offer instead of following what the court has ordered. We believe a contempt is appropriate and ask the court to enter the remedies requested.
Thank you, Mr. Baldwin. Mr. Fuel, good afternoon.
Good afternoon, Your Honor. I don't think there's a disputed fact, but I think that the exact opposite argument is a better reflection. That's why we're here. I think that it's pretty clear that my client has been persisting through significant back issues. We presented the same argument before when we were here for the temporary orders. The evidence was the same. It's getting progressively worse. Wife obviously knows this. We do appreciate that the order is what it is, but my client is not willfully avoiding making payments of any kind. I think that resolving this case really is in the best interest of both parties. I don't think that an offer, an attempt to settle a divorce is ever in bad faith, at least not in my experience. I think that at this point, the only asset that really needs to be gotten rid of ASAP is that Silverado, the truck that my client is supposed to be covering the payment for. It's per the court saw in our documents, I think it's about $15,000 in the red. Getting rid of that asset would hopefully resolve some ongoing issues. I suppose that if the parties want to stipulate to selling the real property, that would also probably resolve a lot of these issues. I think that the evidence is pretty clear that this is not a willful situation. We would ask the court not find my client in contempt. I think that if the court is going to find my client in contempt, loading him up with more civil penalties and attorney's fees and what have you, it's just more finances that will ultimately that he can't pay. Ultimately, it'll get resolved out of the house equity, I'm sure. Again, another reason why we really should just be moving forward instead of looking backward at these types of payment issues. We do appreciate that the house is the most important asset, and that's why my client was able to scrape together the funds he had available and get that done. He does understand, based on this litigation, that the number one thing is making sure that the house mortgage payment is protected, and I don't think that'll be an issue going forward. I don't think it's appropriate to get into the personal property and selling such things. I doubt the parties at this point are going to be able to get anything worth the value that would make a difference long term in this case. Again, if the parties want to get the real property listed and move forward with that disposition, that might make some sense. And I don't want to overstep, but I would point out that the fees associated with coming to court are significantly higher than any potential fees that would be associated with, again, trying to resolve this thing sooner rather than later. I don't think that the evidence supports that this is willful. And I would also point out one more thing. It is in my client's declaration, and I think pretty clear that he knows he can't afford what the court has ordered. He was moving forward with making the plans to get himself back into court to get a second fresh look at what the orders are on the temporary support matter based on the incomes available. And I think the very real issue of his ongoing health and the downturn of the work he's able to do. That's all.
Quick question, and I'll give you a chance, Mr. Baldwin, but I have a quick question. So I saw some of the medical records that you supplied and everything, even the one dated February 23rd lists that he can still work up to 50 hours a week. So is he been working less based on this? Well, it appears as though he's still cleared to work up to that amount through his medical provider.
Right, which is the case. He was hitting almost 70 hours a week before that, Your Honor. And so it is a reduction, albeit, and to be 100% honest with the court, which I always try to be, I had the same response when I read that. I was like, reads a little bit out of the ordinary, since it's clearing you for more than a standard 40 hours, but he was working more than that. And so it is a reduction.
Okay, thank you for clarifying. Mr. Baldwin.
Yes, Your Honor. I guess I'll start and I'll be brief by my standards. I agree. Resolutions are usually ideal, but accruing attorney's fees instead of paying debts that the court's ordered you to pay is problematic, and that's a choice. Court can look at the records. The initial financial declarations submitted on the first round of hearings were full pay statements that showed not just the portion that would be reflective of a check or payment stub, but how the hour breakdown was. Looking at the prior filing, a pay period on December 2nd for the week of the 20th to the 26th of November is broken down by regular hours, overtime hours, how much of that is holiday pay, etc. It is certainly concerning that with those records provided previously and provided to the respondent, the current statements on the financial declaration are just the stub portion, because it does not reflect how those hours are broken down. Looking at the prior, there are periods where in the November 25th paycheck worked regular 40 hours, 15 hours of overtime. And the way the stub's broken down is certainly interesting. It shows regular pay of 55.38 hours on that particular day, 40 of it regular and 15 of it overtime. So then on the overtime line, it's just the additional 50% as opposed to time and a half for the 15.5 hours. So there was 55 hours worked on that pay stub. On the 2nd of December, 45 hours at $30 an hour, 10 holiday at $30 an hour, and some small amount of overtime on that particular pay stub. So the indications from the pay stubs we have is that when he's working that additional overtime, so on December 2nd, that was a check that cleared in the amount of $1372.54 on a gross of $2142. We don't have the pay stub showing whether he's even working 40 hours right now that he has in what was filed. But again, the issue is this has been a long-standing issue, and he's been able to work regularly until the court tells him he needs to pay. And he was able to pay during this entire period of time, at least the part for the maintenance, at least the part for the house and the mortgage and those fees. It'd be a different story if he had paid $1,500 but said he couldn't pay the $1,000. That's not what he did. He paid $300, forcing my client to go to court because he was not responding to her about little things like closing an account or paying for the car payment. And now she had to go through this process to get any sort of action out of him. And she continues to be concerned that's going to perpetuate. We put the matter over only 1 week so we could be heard, but I'll ask maybe to do a presentation next week because there's another maintenance due on the 10th of this month. My client's concerned he's not going to pay and is concerned that if he doesn't have any sort of consequence for this, whether it's being allowed to sell an asset or that the attorney's fee award that the court initially made and makes here, if there is one, comes out of his share of filing the taxes, that he's just going to be in a position where he's able to continue to disregard, leaving her month to month afraid and forcing her to do what he may want, sell the house that she wants to keep. So that's the concern we have, Your Honor. As to the Silverado, my client maintains in her declaration that had not been previously discussed about selling it. If there is a debt and it's underwater and it's given back to the bank, that any debt that exists would go to him would be, I think, the only sort of way. I think that's still going to affect her credit, but if the court were to so order, I don't think my client has an objection. She doesn't drive that vehicle. She's got no problem with it no longer being an encumbrance. But the concern is it's now further under because he's not made a payment, and it's going to affect credit in a significant way. So if the court does authorize its sale, that the debt of it being underwater, at least at this point, be considered as a debt for him, or at minimum that be reserved.
I just want to clarify something. I have a contempt order that from your office. Do you want me to hold off on that because circumstance of it has changed, or do you want me to work off of this?
I'll defer to Your Honor. We did have it, but it had the past due amount of $2,200 in. If Your Honor wants to interlineate, that's fine. But I have no problem. I guess the only issue is then creating additional attorney's fees. If the court's order is closely reflective, then that's fine. I just would then echo the concern that if there isn't some consequence for non-compliance, not just the court saying pay attorney's fees that until the case ends are difficult to enforce in any meaningful way, that Mr. Monday will continue to not pay, will not pay this month, that we'll be in the exact same situation where we're filing another contempt, accruing additional fees. And that's what my client wants to avoid.
I guess as far as the Silverado is concerned, I have confidence that the parties can probably resolve that. If that is something that can be getting off, removed from the books at this point, that may be the most appropriate thing to do. So it's not another issue that we have to deal with. Contempts need to be willful, and there needs to be a showing that there is a willful violation of a court order, and that he's able to follow those court orders and essentially chose not to. I think based on the information, so we are aware that Mr. Monday has some health issues with his back, which is affecting his ability to work as much as maybe he was able to before. That's as far as the court can go. There was, I think that Mr. Baldwin's made a reasonable showing that things substantially changed as soon as the order for spousal support was entered. I think the totality of the circumstances and the submissions that the petitioner made, I am going to make a finding of contempt. I am going to strike the past due spousal support as under the Monday judgment. I'm going to impose a $100 civil penalty Were you still requesting the joint account 135? Or I thought that was resolved as well, but
The amount that was in it, I believe, was only $90 or so, Your Honor. There was an additional deposit that my client had seen in. That money was a joint account that was closed and money was kept by Mr. Monday. So I'll defer to Your Honor. It is still money that was joint, I do believe, but I'll defer to the court. It's a much smaller concern here financially than the attorney's fees and sort of the rest of the issues. So I'll defer to Your Honor.
I'm going to strike out that money from the joint account. I am finding Mr. Monday in contempt, so joint accounts should not be touched. I'm going to impose the $100 civil penalty. I'm going to grant attorney's fees of $12.50. So I'll make those changes in the two parts of the order. Striking the past due support and the money from the joint account, and having essentially the request for attorney's fees.
I'll ask Your Honor, are you making any other orders with respect to what was requested for the remedy requested in the argument in my client's petition or declaration that the firearms be sold, or any other?
At this point, no. I think that's actually a quite a creative suggestion, and I think Mr. Monday needs to be on notice that if he can't keep up with this, then the court will likely look towards a remedy of another nature, and if that means selling items and withholding the money to use for non-payment, and then that's definitely something that the court will consider. But at this point, I'm going to give the benefit to Mr. Monday that he'll be able to make the payments in a timely fashion moving forward. But if that's something that cannot happen, then I would definitely consider that.
My only request, Your Honor, I guess, if the court was considering a review, maybe we do something in 2 weeks that the parties can strike by agreement if the next payment is made on the 10th. That would get us in front of Your Honor on the 21st as a review on this, and it would maybe be in a position where if that payment is made timely, Mr. Fuel and I can contact court admin and the clerks and ask to strike it, but I'll defer to Your Honor.
Was that be in lieu of the April 25th date that was
Yes.
suggested on your?
Yes, Your Honor.
And that probably is fine. I know my client anticipates being able to make this work. And I know I'm on, I would be available for 2 weeks if that's necessary. And I'm sorry, and just to follow up, I also agree with Mr. Baldwin. He and I can work well together generally. So I think if we can get that taken care of, we'll be able to get that off your docket.
Okay, so I just made that change then under section 12, review on March 21st, 2023 at 1 p.m. And I'm just going to also interlineate that parties may strike upon agreement. If it becomes a problem, I'm assuming it'll be raised again, but I'm going to put 90 days.
And for whatever it's worth, Your Honor, I think that probably, with the possible exception of Mr. Baldwin, I think probably everyone agrees that the other places where the money needs to go is probably a priority. So we'll do with this as we can.
This is your motion.
Yes, Your Honor. So we're here today on my client's request for to establish temporary child support. In addition, we're asking that Mr. Davis be ordered to pay costs associated with a bed bug extermination at the prior shared marital home. And we're asking that he be ordered to pay the $1,800 for the 2021 tax credit that my client should have received last year. In Mr. Davis's response to our motion, he proposed a $621 obligation to begin on March 1st. I spoke to my client before court today, and she said she would agree to that amount, but we would ask that our most recent child support worksheet be adopted and that the $621 be considered an agreed deviation. The bottom line is that there's a big disparity in the incomes of these parties. My client has extremely limited financial resources. Her income is SSI and SSDI for a total of $934 a month, only $852 of which can be calculated per as income per RCW 2619-071. Mr. Davis, on the other hand, has said that his income is about $4,562 a month. So it's true that my client receives public benefits, as Mr. Davis pointed out in his response pleadings, specifically HUD voucher, and currently she receives energy assistance. She's incredibly lucky to receive these benefits, but they are not guaranteed, and they shouldn't be, in our opinion, calculated as income for the purpose of determining her support obligation. Mr. Davis or Ms. Davis, my client, has supported Braden on her own since this case was filed. In response to Mr. Davis's breakdown of expenses, my client provided a monthly breakdown of where her income goes starting January 2022. Some months she has $70 left, some months she has a little bit more, but some months she is in the red. When emergencies arise, she has no safety net. If her car were to break down, she wouldn't be able to afford repairs. There's no extra money for clothes, shoes, haircuts, events, or activities. Mr. Davis understandably has his own set of expenses, but my client is desperate for some sort of financial assistance from him at this point. In regard to the 2021 tax credit, Mr. Davis in his declaration said that that money was used to pay community bills. The timeline makes that questionable / impossible, though he would have received those monies sometime in 2022, at which point my client was already responsible for all the household bills. And regarding the bed bugs, it's true that Mr. Davis has not lived in the home, but my client cannot afford on her own the extermination costs. The last time this happened, it cost several $1,000s, and she would be able to possibly pay for it on her own had she had some sort of assistance from Mr. Davis. So in conclusion, we believe that our child support worksheet filed on February 27th, most recent one, has the most accurate information available. It includes Mr. Davis's most recently disclosed income. It provides my client's most recent income, and it includes the benefits that she receives in section 22F and G. We're also asking that the court, again, order Mr. Davis to pay retroactive child support payments starting June 2022 when this was filed, and that he be ordered to pay the $1,800 child tax credit and costs associated with the extermination.
Thank you, Ms. McLean.
Thank you.
Thank you very much, Your Honor. So first off, in regards to the child support, Judge Hahn heard this argument last year, and at that time she reserved child support because there was a representation that there was an administrative child support order in the works. My client was never served with an administrative action. We acknowledge that he owes child support. We're asking that the court not enter this retroactive. At this point, he has paid, he's been the sole person to pay for his professionally supervised visitation, which went without a hiccup. All of that went very well, and he's now transitioned into unprofessional supervised visits. He's also had to pay for all of his housing and other additional expenses without the benefit of any financial support from outside services. He is also the only person here that's paying for an attorney because Ms. Davis's attorney is court appointed. So at this point, my client doesn't have a money tree out in the backyard where he can generate money. His funds are exactly what his funds are. He also is paying over $35,000 in community debt, as well as he has tax debt. And I'll get into the taxes in a moment, but right now he has housing expense of $880 a month, that's just for his rent, $575 per month for a car payment, $97 for car insurance, $300 for community credit card debt, $100 for the 2021 tax debt and his 2021 tax debt. And now we're going to anticipate approximately $621 per month in child support, which basically means that he has about $1,000 left to pay for his attorney, for his food, for utilities, for transportation expenses beyond the car payment, fuel and repairs and the like. That's pretty limited. He doesn't have any savings. Otherwise, counsel would have produced that through sealed financial source documents because we've shown everything that he's got and he is living paycheck to paycheck. And again, my client cooperated in transferring the HUD application over to Ms. Davis after their separation so that she was the one that would receive the HUD housing support. That HUD housing is $1,058. It pays for more than 100% of the home mortgage bill that she has been paying. She also, as outlined, does have food assistance. I guess my query is whether or not child support is going to then negatively affect some of those monies that are available to her, because I think that they'll take that into consideration as far as the financial resources within her household. So we're proposing that the court order the $621 per month child support effective with March, reserve any determination of retroactive child support in this case. In addition, with regard to the taxes, as far as I understand, Ms. Davis is asking that my client pay her for $1,800 that he would have received in 2021 for tax credit. What I think that they're identifying, quite frankly, as stimulus monies. Those would have been received in 2021. My client tells you what he received in 2021 was applied towards utility debts that he had continued to pay post-separation. And depending upon when those were received in comparison to when they separated, my recollection is that they separated in July of 2021. Those would have been paid towards those community expenses prior to their separation as well. We have filed under seal proof of his 2021 tax return. Ms. Davis demanded that they file separately. She had no income to claim. She claimed the child as a dependent. And as you can see from the sealed financial source documents that we filed on both of their tax returns, Ms. Davis, and if you take a look at page 9 of that attachment, Ms. Davis received a refund, and this would have been for the 2021 tax return. She would have received this refund in 2022 of $4,600. She claimed the child as a dependent. And if you take a look at page 9, line 29, she claimed the American Opportunity Credit of $1,800, and she claimed the recovery rebate of $2,800. So all of that was taken into consideration in encompassing her $4,600 return. If you go back to page 1 of that sealed financial source document, you'll see again that my client filed separately. And on page 2, it shows that he did not have an American Opportunity Credit. He did not have a recovery rebate. So all of those benefits went to her. And he owes $2,843 from that 2021 tax filing. He has engaged in, or he's in an installment agreement with the IRS where he's paying $100 per month. And we provided the updated documentation at page 6 showing that he currently owes that's wrong page, page 7, that shows he currently owes $2,076.28 to the IRS from 2021. Unfortunately, we haven't been able to reach an agreement as it relates to 2022. I am asking that the court reserve on the issue of 2022 taxes because the court has not made that determination. And there should be an effort to make whatever the best filing status is for the community. We need to be able to, if we can't reach that agreement, which apparently at this time we haven't been able to be able to come back to court to make our respective pitches so that we know what the potential numbers are with them filing separately again or with them filing jointly. So I would ask that in the child support order that you reserve as it relates to 2022 taxes moving forward. But at this juncture, my client hasn't received an additional $1,800 that Ms. Davis hasn't already received or benefited from. He doesn't have any monies available to pay her. And to be quite honest, I'm not sure why we're piecemealing this one issue. This is an issue that if the court thinks there's validity to it, it should be reserved for the time of trial when the court can take a look at the entire global analysis of the different financial arguments by both parties. The last issue again relates to the bed bug issue. This obviously has come up clearly after they have been well separated. It is not an issue that is my client's fault, and arguably it's not Ms. Davis's fault. She suggests that maybe they came in from the workers due to this flooding issue. It needs to be submitted to the insurance company. We need to see if the insurance company will cover this. I've also forwarded to counsel the proof that Interstate Pest has now indicated that there is a debt of only $135.13, which is significantly different than this initial claim of 700 and some, I believe it was 700 and some dollars. Counsel and I are communicating. She's been busy with court. We both need to know, and our clients need to know, how much is it going to be for the bed bugs, and let's get that issued to the insurance company to see if they will cover that issue, because obviously neither of these parties have the funds for that issue. But again, that shouldn't be my client's responsibility, since he has all of his own financial obligations as far as his household. So we would ask that the court if either deny or reserve on this 2021 issue for $1,800. And again, I've outlined in the tax returns where I think that that's already been consumed by Ms. Davis, and deny at this point the bed bug issue. If anything, that should be her separate obligation, and then award for the child support at $621 a month commencing March 1, reserve the 2022 taxes or the allocation of the child as a dependent. And we do believe that the court should adopt our proposed financials for purposes of child support.
So to answer why are we piecemealing this, it's because my client is desperate for some sort of financial assistance. She is not able to meet all of her obligations on her own at this point. And we would agree to reserving on the 2021 tax issue. We do have documents that we can provide on a later date if necessary that probably should have been provided here that show that she did not receive that, but was entitled to it. So we, like I said, we would agree to reserving on that, and also reserving on the 2022 tax issues. I do think that we will be able to come to an agreement. My client does want to do what is ever best for the community in this instance. Regarding the bed bugs, the $135 I spoke with my client before court today was for the inspection fee. So that was when they came in, they looked to see how big the issue was, and then my client wasn't able to pay that then, and she still is not able to pay that inspection fee now. She's not certain how big of an issue it's going to be. She's been bombarded by working with the home insurance people over a water main busting back in November. It's been a very chaotic situation. But it's next on her list of things to take care of. So our requests remain the same. We ask that our financials be adopted. We agree to the 621 as agreed deviation, and we're still requesting the bed bugs.
And remind me what the estimated cost of that is, between $700 and $900, or I feel like it was.
So as of right now, my client doesn't have a good idea of how much it is. She knows that last time they had a bed bug infestation, it was, I think, several $1,000s. She's hoping that she's caught it earlier this time, and they're not going to have to do so many different rounds. But at this point, I don't have a good answer for you.
And I thought that I saw a bid for, I thought it was like 700 and some.
I thought there was a bid, but there was also something that indicated that they may need to come back and that fee would be separate. And I don't know that there was an estimation for that, but okay.
Ms. Powers is also involved on behalf of the state.
Thank you for reminding me of that. Ms. Powers, any comments from you?
Your Honor, just briefly, the state's interest is because the child's receiving state medical in this situation, and part of our interest is that worksheets are entered that correctly reflect the incomes of the parties. I've reviewed both sets of worksheets from the parties and believe that the mother's worksheets submitted February 27th are the most accurate. The only income that should be listed for the mother under statute is her SSA benefits. It should not include her SSI or her food benefits or HUD benefits. Additionally, I would just ask that when the order is entered, that it assign both parents to pay their proportional share of uninsured medical expenses.
And just so I'm clear, Ms. Powers, that's the $934 amount. Is that correct?
For the transfer payment?
No, for the income for mom.
No, the mother's income should be the $852.40.
Okay, so I have an old child's work. I guess I have an old. All right, I'm gonna throw that in my recycle bucket over here then. All right, so here's.
I have her SSDI at $934 a month. That's what the most recent discovery provided, and I think that we filed that under seal.
What I was able to see under seal that was filed February 10th showed the SSA at $852.40 and the SSI at $82. So they should be split apart, and the SSI should not be included as part of the income.
And that was something I didn't realize until reading the statute again after receiving Ms. McLean's pleadings. And so the February 27th reflects all of that, but it was not provided to the court as a proposed order.
Gotcha. Okay. All right. So first I'll adopt Ms. Ernest's proposed child support worksheet. And I'll sign that. We can sign that ex parte. I will set child support at $621 a month to begin March 1st, 2023. I'm going to reserve on retroactive child support at this point in time. That can be raised at trial. And it sounds like there's an agreement to reserve on the 2021, 2022 taxes for two different reasons. 2021 to get more information, 2022 to see what benefits the parties and how to file for last year. So then that leaves us with the bed bug situation. And I guess before I move to that, Ms. Ernest, I have a child support order and a temporary family law order from you.
Yes, and the child support order will need to be updated, obviously with that 621 number, and their incomes will also need to be updated based on the newest child support worksheet.
Okay.
As well as the temporary order.
I'm going to just bag all of these and we'll have recycle. Okay. Obviously the bed bug situation is concerning. I completely understand both parties' requests. It's a tough situation. I would agree that the initial contact should be with insurance. If they were removed from the home based on another issue in the home and this occurred as part of the fix to that, then I think this should go through insurance. So I'm not going to order dad to pay that at this point in time, but essentially I'm going to ask mom go to insurance first. And if that does not work, then I'll reconsider the request to have father chip in to that for that remediation.
And when you say chip in, are you suggesting
basically just keep the issue open, but I think we
Okay.
need to go to the insurer first
Okay.
because based on my review, the water main broke. They were forced to move home out of the home, return to the home, bed bugs. I feel like it's a connected issue and the insurer should, I'd like to think the insurer would take care of that. If that is not the case, or if it's a languishing issue, then I'm happy to reconsider how to potentially resolve that sooner. Do you want to go 1 week, 2 weeks, 3 weeks?
I think we'll actually be here next week anyway, so next week would work.
21-300-08-908. Okay. 14.
and one McLean appearing on behalf of the petitioner, Sean McGill.
I'm also
Mike-
here, Your Honor.
All right. Thank you.
And my client is appearing pursuant to the order to show cause, even though he technically has not been served with the same.
All right. So I have believe we're working off a motion to show cause for contempt that was filed by Ms. McGill on the 14th of February. Is that correct?
Correct.
All right. So Ms. McGill, this is your motion, so you can make any argument. And I just want you to know I have reviewed everything that you filed.
Thank you, Your Honor. This is the petitioner, Sean McGill, has committed contempt of court by violating the parenting plan. He has violated the joint decision-making ordered by the court on 6/29/21. He has also violated paragraph 8, section B, number 1. Sean has also been warned by my former attorney, Ms. Blondin, by email and letter on 2/24/22, almost a year ago, for violating the parenting plan then. Yet he continues to do so. And I've had no recourse but to bring this action before Your Honor. He willfully, intentionally, and in bad faith has violated this. And unless the court steps in at this time, he's going to continue to do it. I've just recently found out that my daughter has taken driver's ed, no knowledge of it to me whatsoever. That is stipulated in the parenting plan under joint decision making. I only found out because I needed insurance papers, and I saw that her name was included on the insurance forms. That was something that I should not have missed. I should at least been informed And he just refuses to do that. And I don't believe that he is going to continue to give me the information that is required that the court has said I am entitled to. And that's evident by him sending in a proposed order that he wants to change the parenting plan again. The joint decision-making, he wants to be sole person who makes all those decisions, and that's just not fair. I just recently found out, and just because he told me that I need to go on the school site and look for my daughter's school sports, that she recently was in wrestling, and I had no idea of that either. And he's just not.
I would object to any information that's outside the scope of the declarations.
All right, that's noted. I'll let you continue. I'll only consider what has been before the court by declaration, but go ahead.
Okay. Unfortunately, me being pro se, I can't ask for fees to cover my time and my expenses. I asked the court for a civil penalty of at least $500 for Sean, the same amount he requested for attorney fees. I believe that that's only fair. I also would like for him to take a parenting class. He obviously doesn't know how to co-parent. I also request that he provide the family app, our family wizard, and that he pays my portion of that. Maybe we can have some sort of communication that way. I don't know if that will work either. But those are the things that I'm trying to request. And another thing, I was really shocked that my daughter, or our daughter, is no longer in counseling, and that was ordered by the Judge Scudder. That was just plain shocking, and she definitely needs counseling. And I believe Mr. McGill would agree to that. This started when Lexi was 13, so there's been a year and a half. She'll be 16 in April. And I just don't want her to come back to me one day and say, Mom, how come you didn't stand up for me? How come you didn't try to protect me? Why didn't you fight for me? And that's what I'm trying to do now. I'm just trying to have information on our daughter. I don't even have pictures of school sporting events because I was never notified that that's what she was doing. And that's a shame. It really is. I think that the petitioner has definitely talked about the divorce to our daughter, just by the things that he is saying.
I just object us to speculation.
I put that in my declaration.
All right, it's noted.
This is the plain facts. There's no getting around it. Sean McGill has violated the court-ordered parenting plan and should be sanctioned. And I given the relief that I requested in my motion for contempt of hearing. There's just no way around it. He has committed contempt. Thank you, Your Honor.
Thank you.
As far as housekeeping, Ms. McGill did attach to her initial declaration at page 7 a copy of the insurance binder. We are asking that be removed from the public file because there are identifiers, private identifiers that are affiliated with that document. It needs to be filed under seal. So we would ask that that be removed from the public filing and placed in the sealed filing. Second, as I noted at the top of this argument, my client has not been personally served, obviously, which is a requirement under the statute. My client, at least in his declaration, has asked that you consider striking this. Obviously, we are hearing this at this juncture. And ultimately, we're asking that the court find that Sean McGill has not willfully violated a court order. We're asking you to deny Ms. McGill's contempt request and award my client $500 in attorney's fees for having to respond to this. Clearly, when the court reviews through the parenting plan in light of the allegations by Ms. McGill, there are some conflicting provisions within this parenting plan as it relates to paragraph 14A about my client having the ability to make decisions on activities during his time, compared with the joint decision-making, and as well as in 14B. There's also conflicting provisions there. First off, my client is not obligated to provide documentation that is available to Ms. McGill through her own efforts. And clearly she's not made those efforts. Even in her argument, she acknowledges that she just now is finding out information, I'm assuming through Skyward, which has been available and accessible to her since her daughter's been in school in Kelso. So addressing each of the issues, and I would note that the majority of these issues, quite frankly, should, if anything, be time barred. They are so old that clearly if there was an allegation that should have been raised in a timely manner, and she has not done so. Her claim number 2 is a claim from nearly a year ago. My client tells you that Lexi signs herself up for various programs within the school district. If there is a fee, she lets him know and he provides that payment. And again, that's information that's available through the school sites. My client is not obligated to provide her with pictures. My client is not obligated to take pictures on the first day of school and provide those to Ms. McGill. Those are completely frivolous requests and not contemptible action on my client's part. Number 3, she says my client, on number 3, my position is that my client should not be found in contempt, again, for failing to provide a picture of Lexi on the first day of school. There's nothing, as I indicated, that requires him to do that. And as you can see, not only through my client's declaration, but through the guardian ad litem report, Lexi wants absolutely nothing to do with her mother. She does not want
Objection, Your Honor.
What's your objection?
Well, first of all, this is a report about contempt, not about what the guardian ad litem had to say. This is he violated these orders that were ordered by the court, not what the guardian ad litem to say. The guardian ad litem is not the judge.
Okay, that's noted. Go ahead, Ms. McLean.
As you can see from the guardian ad litem report, Lexi wants nothing to do with her mother, had been in counseling specifically because of actions involving her mother, actually missed her 8th grade graduation awards program because her mother came to that program and caused a ruckus. So this is a mother-daughter relationship that is broken. And what Ms. McGill is attempting to do is to punish my client for her own lack of parenting relationship with her daughter. So our position is that the court should not enter a finding of contempt for my client not taking a picture of Lexi and providing that to Ms. McGill pursuant to her demands. Number 4, Ms. McGill is asking that my client should be held in contempt because Lexi was out of school, and the documentation with the school clearly shows that she was sent home ill. She didn't go to a doctor's appointment because a doctor's appointment wasn't necessary. She was simply sent home ill. She stayed home. That's not a contemptible issue. Didn't require any decision-making on my client's part. Number 5, 8 months ago, she asked Mr. McGill about counseling. The child had been in counseling since shortly after this action commenced. When the child turned out of counseling was a decision between the child and the counselor, not a decision between my client and the counselor. And there's been no documentation that has suggested that that was my client's decision. As the court is well aware, the expectation is that people will basically term out of counseling when they've addressed their issues. And clearly the fact that she's not had contact with her mother has removed a lot of those circumstances which required that counseling. Lexi concluded her counseling over a year ago, and clearly that's documentation and information that Ms. McGill could have obtained from the counselor had she put her foot forward in doing what she needed to do. It's not my client's obligation when those are available to her. He should not be found in contempt for that. In October of 2021, so a year and a half ago, she's now suggesting that my client should be held in contempt because Lexi missed school, again, because of illness, which is clearly identified in the school records that were accessible to her. Again, no doctor's appointment was necessary, and she's had this information now for 17 months. I'm not sure why we're here having to defend against this type of a claim. Clearly, we're asking that the court not find my client in contempt. On number 7, this is the issue on the insurance. Lexi did complete driver's education. My client has not asked Ms. McGill to provide financial support. Lexi was adamant that she does not want her mom involved in any of the decisions. And This is where some of the difficulty comes in. Lexi is a very smart child. She gets excellent grades. Ms. Fellows, who completed her report and filed that back on October 12th of 21, specifically recommended sole decision-making due to the fractured mother-daughter relationship. And Ms. Fellows concludes that given no contact currently by Ms. McGill, she's had no contact with her daughter in nearly 2 years, that it would be impossible for Ms. McGill to weigh in with an informed decision on any decision-making issues relative to Lexi. So her recommendation was that Mr. McGill be given sole decision-making since he's the only involved parent. Obviously, what that does is that places my client in a position of violating a court order that requires him to continue to encourage the relationship between the mother and daughter, which he has continued to do. And I would suggest that it's not appropriate to handle these issues in a vacuum, as Ms. McGill is attempting to do. In fact, it does place my client in a catch-22 because in the first instance, it involves Ms. McGill and Lexi's strong feelings against her, and it further risks damage to the mother-daughter relationship. So if my client approaches Lexi about, this is a decision that needs to be made jointly, and she's adamant she doesn't want her mother involved, that's going to further fracture. And that was the findings and recommendations from Ms. Fellows. On the other hand, if you not involve her in decisions, then potentially that places my client in a situation where he isn't complying with joint decision-making. So he's darned if he does, and he's darned if he doesn't. And the focus needs to be on Lexi. What is in Lexi's best interest? And in this circumstance, again, Ms. McGill is not an involved parent. That relationship has resulted in the child having counseling for an extended period of time, and the relationship still has not resolved itself. So we're asking that the court enter enter a finding that there has been no contempt, and that ultimately a sole decision-making should be awarded to my client given the circumstances. The next issue is in regards to haircuts. Lexi is 16 years old. She decides when she wants to get her haircut, and Mr. McGill does facilitate getting her to those haircuts, but it's Lexi who makes those decisions, as any young woman normally does. The next issue that she raises is this claim that my client should be held in contempt because he's gotten her ears pierced or hasn't communicated with her about getting her ears pierced, which she agreed that that could occur. Lexi's ears have not been pierced. My client has not done that. Again, totally frivolous. There's no reason why we should be here on that. The next allegation is that my client should be held in contempt because he didn't facilitate Christmas gifts from her to Lexi. And again, Lexi does not want the gifts, but again, she's putting him in the middle of potentially resurfacing these ill feelings that the child has for the mother. It's the mother that needs to repair her relationship. She needs to stop putting my client in the middle of that, but that is not contemptible. And then finally, Ms. McGill suggests that my client should be held in contempt because Lexi removed herself from band and signed herself up for tennis. Again, she's a smart young lady. She's an involved young lady. She has made those determinations. My client shouldn't be faulted for those choices that the child makes when she's signing up for classes and events within the school system. Again, all of that is available to Ms. McGill if she would take her responsibilities seriously in making sure that she keeps herself apprised as is ordered in the court. Quite frankly, we see this as petty sniping. This needs to stop. We're asking that the court deny the request for contempt, award my client $500 in attorney's fees, and adopt the modification language that we've proposed, paragraph 13 of our contempt order, which allocates sole decision-making to my client.
All right. Ms. McGill, any response?
I do, Your Honor. The reason that I believe that we didn't give Mr. McGill a copy of the contempt order was because he works out of town quite frequently. And I didn't think that he would be available for that. And besides, his attorney represents him, so I would assume that she would give that to him. These things that I put on the motion for contempt were examples, not things that I was requesting to be a participant in. They were to show the court how he refuses to answer just the simplest question that I have. And the relationship between my daughter, our daughter, and myself is not good. She's a teenager. She has so many influences with her right now. He works out of town most of the time. She is left at home with my mother-in-law, who doesn't like
I
me.
guess I would just interpose another objection. We're getting far afield as to the issues that are before the court, and certainly exceeds the scope of my argument.
I would agree. So let's talk about the motion for contempt.
All right. And Miss McLean went over about Lexi's illnesses. Here's the thing that I was trying to bring up with those examples. I am not notified when she's ill. I should be. I'm her mother. Whether he likes it or not, I'm her mother, and I deserve to know when she's ill. I don't find these things out unless I go on to Skyward every single day and check the attendance records. It wouldn't kill him just to say yes or no if she was ill, just to let me know for that day. It's not hard to do. Counseling was ordered by the court. I'm not a lawyer, but I would assume that if the court orders counseling, that the court is the one that would determine when it stops. For her to make that decision and Mr. McGill not be a part of that, that's not very good parenting. I understand probably why she wants to quit the counseling. I'm sorry, I have a lot of people out on the side, if you can hear that. Her haircuts. We have been going to the same hairstylist for years and years. She knows our daughter's hair. She has difficult hair, and the hairstylist knows it. And that's why I asked who cut our daughter's hair, because I was curious to find out why they didn't take her to the regular hairstylist that we normally go to. These are not frivolous questions. These are just questions that I'm asking Mr. McGill. It's not like I ask him a question every single day. I ask a question maybe once or twice a month, things that I'm not aware of. The last one with the illness, she was sick for 3 days. I had no idea. It's not the fact that she doesn't go to the doctor. I don't need to really know that portion of it because that's Lexi's private, but I think I deserve to know when she's sick. With the school, she's saying I'm sniping. There's no sniping here. If you read the text messages that I gave as an exhibit, you'll see that there's no sniping. They're regular questions. They're just honest, simple little questions that he could answer. And that's why I'm asking for the family app. Hopefully there can be some sort of communication between us, because evidently there's none at all. The only thing that is available to me online on the school site is whether what sports are being played. I have no idea what sports Lexi is in. And the only reason I found out about the one sport was I got online on the school site, like Mr. McGill asked me to the last communication that we had. And that's when I saw that she had done wrestling. So he's not giving me her extracurricular activities so that I can at least be in the know for her. And it's just really sad that he doesn't want to do that. But the fact is, Your Honor, these are not frivolous, and he did commit contempt of court for them. And the rules are the rules. He should be held accountable, because if he doesn't, it's never going to stop. He'll just keep thumbing his nose up at this court order. So I asked the court to give me the relief that I asked in my motion for contempt hearing. Thank you.
All right, thank you, Ms. McGill. I reviewed this several times, and I think, frankly, the different judicial officers see different things. So my first thought was something that Ms. McLean pointed out, that it's kind of convoluted, that it says joint decision-making on all these things, but that the parent that has the child in their possession, so to speak, is the one that gets to make all these decisions. That doesn't Those don't mesh. That doesn't work out. So if Mr. McGill were to follow 14A of the parenting plan, then he would be in violation potentially of 5A. If he follows 5A, he would potentially be in violation of not following 14A. So clearly that's an issue that needs to be fixed. I also completely and totally understand Ms. McGill's want to be at least tertiarily involved in her child's life and have this information. A lot of this, though, I would agree with Ms. McLean, is not the responsibility of Mr. McGill. There's information that can be received through the school. I think, frankly, the driver's education and driver's license, that probably should have been relayed to mom. It's specifically outlined under 5A in the parenting plan. Driver's permit and license, as is extracurricular activities and haircuts and that kind of thing. But let's be honest, some of that stuff isn't as kind of noteworthy as others. Do I see this as a knowing and willful violation of a court order? I don't know that I don't think I can make that decision at this point. And I frankly don't think I can make that decision because I think there's an error in the parenting plan as it's entered, because it contradicts itself. If he does what it says in one part, then he's directly violating another part and vice versa. So Mr. McGill kind of is in a no-win situation here. That being said, I would agree with Ms. McGill that it wouldn't hurt Mr. McGill to share some of this information when she requests it. She indicates there's a few questions a month. That doesn't seem to be too much of too much to ask of Mr. McGill to let her know some of the things that she's inquiring of. Is it his responsibility to proactively reach out to her? It depends on which part of the parenting plan that's in place you refer to. So I'm not going to make a finding of contempt. I'm not going to impose any sanctions or attorney's fees for either party. I do think that we need to fix the parenting plan as it is. What is one thing you didn't touch base on is Ms. McGill's, and this is to Ms. McLean, Ms. McGill's request for some kind of a parenting app where information can be exchanged by way of our family wizard or something like that. Did you speak with your client about that, or do you have a position on that?
I don't know that I did. If the court is inclined to provide for a parenting app, I think that there are free apps out there, and certainly Ms. McGill is full-time employed and has the ability to pay for her own app. My client shouldn't be responsible for that, particularly since I still don't think she pays any child support. My client is raising this child without any financial support from her at this juncture. So if the court does order some type of a parenting app for future communications, she should be responsible to put her own bill. But I know, I think it's Talking Parent is free. I think they also have a paid version, but again, we're talking about a 16-year-old. I don't know that we really need a level of a parenting app in this day and age, given the fact that they do text or can text, and each party can save and print off their own text as needed.
And are we still, are we, because this is a temporary parenting plan, is that correct?
Correct.
Yes.
So we haven't, have we done an MSC? How far are we along in this process?
We've done an MSC. We were unsuccessful. I was waiting for supplemental discovery, and then Ms. Blondin was no longer Ms. McGill's attorney. So I'm thinking that we're in a position now where I'm probably close to noting this up for trial.
Okay.
I don't think we're anywhere close to trial, Your Honor.
Okay, well, I just was curious about where we're at. So on a temporary basis, I'm going to encourage Mr. McGill to respond to the questions posed by Ms. McGill in regards to your daughter. I'm not ordering that. I'm encouraging it. Ms. McGill, I'm encouraging you to sign up for any notifications from school, so you can keep track of whatever you need to keep track of with regards to your daughter. As to your concerns for counseling, my understanding is that the counseling, that she attended counseling for, it was close to a year and a half. And it was a recommendation from the counselor that, that your daughter agreed to no longer attend counseling. So I don't know that it was she chose to quit counseling. I think the counselor felt that she was in a place where she could move on without further need of counseling. I don't think that was a decision based on the information that was provided. I don't think that was a decision that she just got to get out of counseling. So I'm not as concerned with that as you are. My hope would be that if she expressed any need for counseling, that she would be able to jump right back into counseling if that was something she felt she needed. I am gonna repair the parenting plan as proposed by Ms. McLean. So I'm gonna limit the decision-making to match 15B or 15A, excuse me. So I'm gonna give a decision 14, is it?
14A.
14A, sorry, I said
That's
15B,
okay.
15A, 14A. So at this point, since she's full-time with Mr. McGill, I'm gonna give him the decision-making on a temporary basis until this matter proceeds to
I
trial.
want to just indicate at paragraph 6 that both parties' request for fees is denied.
I struck it, but I'll strike it and then add denied.
Okay.
Okay,
Great.
thank
Can
you.
you explain that, Your Honor, what that meant?
Which part? I'm sorry.
Striking what?
Oh, you request $500 in fees and they requested $500 in attorney's fees from you, and I'm denying both requests.
All right.
So
And-
nobody pays anybody anything for this.
Okay, and with Lexi's counseling, I was just reading what the judge had sent in an emailing to us, that the child still maintain her counseling. So that was why I had said that, because it was ordered by the judge.
I perfectly understand that. There was some supplemental information that was received, and my understanding was that it was the counselor suggested it and it was agreed upon to discontinue.
I have never received any kind of information from her counselor.
I'm sure
stating
you
that.
can reach out to her counselor and request that.
Okay, and if it's not available, can I come back to the court?
Best of luck to you both. You can always come back to the court.
Thank you very much.
All right.
Your Honor, I
best of
believe
luck to you
number
both.
2 and 3, although not anticipated to be extremely short matters, are going to be shorter than the cases that have been heard so far. Recently.
Oh, Ms. Jeffers. Go ahead.
Sorry. Thank you, Your Honor. So mother is requesting a finding of contempt against father, modification of temporary orders and attorney fees. With regard to contempt, father failed to follow the child support order. Specifically, Section 8 has been violated. He's been ordered to pay $896 monthly. He's failed to do so. At the time of filing, he was owed over $3,400. He also violated Section 21. He has not paid his share of the child's medical expenses that have been ongoing. I think it's been over a year now, just about a year since those have been incurred. Similarly, he violated the August 23rd, 2021 order again a year and a half ago, but by not engaging in a parental risk assessment with the GAL's input. Father claims the inability to pay, but father immediately quit his job once child support was ordered. He has absolutely no disability. He also dropped the children's insurance without notice to mother. And his current actions show his ability to pay, because in that same time period, he bought a brand new full-size pickup truck, a motorcycle, guns, football tickets, and we even provided a receipt of a trip that he purchased for Disneyland, which is doesn't include the airfare, lodging, anything like that. And that was over $1,000.
Well, and I have to object, and I can review the motion again, but I don't believe any of that information containing various purchases by my client was contained within the underlying motion. I believe that was contained in the reply. My client didn't have the opportunity to respond to that.
Well, in any event, I submitted the information to the court. The court can take it with as it is. The claim that father never received notice of medical expenses is blatantly false. Mother submitted documents showing that she has provided notice to father on multiple occasions, and I will indicate that any information submitted in the reply was directly in reply to father's response and his knowledge. Mother also requests the temporary family law order be amended to allow Matthew Fuller to reside in the home with mother and the children. Historically, mother and Mr. Fuller have been in a relationship for 7 years. His children and the children in this case are significantly bonded, and the children are significantly bonded to Mr. Fuller. Contact was limited in October of 2021. The court indicated it was waiting for a conclusion of the criminal case because of concerns of witness tampering. The case originated based on a report from father. The case is concluded. It was determined to be a disorderly conduct, non-domestic violence. The children are not listed as any kind of victims. No children were assaulted. And quite frankly, as mother indicated in the original declaration, father coached the children on what to say because father was seeking to change the parenting plan. He actually waited 4 months after the incident before proceeding because he was waiting to proceed on the change to the parenting plan. As background, the children have quite frankly suffered significant mental health declines based on father's actions in the past. Behaviors it appears that he continues to engage in. He keeps saying things in his declaration. The children shouldn't even know that this motion's happening, quite frankly. And this is something that the court has made clear to him several times. Last time we were in court, the GAL recommended counseling for both Mr. Fuller and the child. Both have been complied. Both parties' counselors believe the issue's been dealt with, and both have improved significantly. All parties are ready to be reunited at this time. Mother doesn't necessarily oppose the children talking to the court. The concern is father's history of serious coaching, threats if they don't comply, those kind of issues that continue to keep coming up. And these children, quite frankly, they have some behavioral issues, and they shouldn't be put in a spot to where they're feeling pressure to say something one way or not. It's just not appropriate. The court never said that this particular issue could not be addressed prior to trial. As indicated in the clerk notes, it says that this schedule, the visitation schedule, stays as it is until trial. And then the court went on to address other issues, but certainly it is appropriate to address this issue. Full compliance has been completed at this time. And quite frankly, Your Honor, all of my trials in Cowlitz County keep getting pushed over because of criminal priority. So who knows when we'd actually be able to get to trial. Mother is requesting a finding of contempt for the reasons that I've talked about, asking for modification of the temporary order so the family can be reunited. She's also asking for attorney fees. When we were here last week, father indicated that there was a new incident that concerned Mr. Fuller that the court needed to be aware of. I did submit the documentation just showing that that was not true and that I believe it was just an attempt to inflate attorney fees. Thank you, Your Honor.
Quick question, Ms. Jeffers, there was a request 7 months ago in front of Judge Hahn for the same request to amend the temporary orders to allow Mr. Fuller to return to the home. She denied that and deferred it to trial. What has changed in that time?
So, Your Honor, and that's what I was getting at. I know it's kind of confusing. So what Judge Hahn's position is that she did not want the no contact order changed until there was a resolution of the criminal case. What she was mainly concerned about was witness tampering with regard to Mr. Fuller and the child. And so she did indicate that we could bring it back once that issue was concluded. And again, when she's referring to no changes till trial, she's talking about the visitation schedule, because at the same time, father was asking to change the parenting plan. So we had two opposing motions. With regard to father's motion, she said, no, there's not going to be any more schedule changes until trial. With regard to our issue, she never made that statement. You can look at the clerk notes and say, she says, no, visitation schedule is not going to change till trial. And then she moves on to the other issues before the court.
Okay, thank you.
And I would ask the counsel if if Judge Hahn made some sort of ruling that the no contact order was tethered to the criminal case being resolved, I'd ask for her to cite some sort of order. What I'm looking at is the minutes that I've cited in Exhibit A of my declaration, where the court specifically says they're not making any changes. This matter needs to go to court. Mr. Fuller not to have contact with the children. Those are made simultaneously from the hearing notes from August 23rd, 2022. So it's not my understanding that Judge Hahn made, again, this tethered to the criminal case. In fact, when we were before the court in August, we were addressing the child attempting to get for a second time, again, involving conflict regarding Mr. Fuller. And at that point, there was no information before the court regarding the criminal case. Yeah, and I did the arrow and I apologize. It looks like some of the printing, but court ruling matter will need to go to trial in order to sort out issues. Court will not make temporary change. Current order stands, Mr. Fuller, not to be in contact with children.
All right. And any other comments, Ms. Gilmore? Well, that was more a response to my question, but your response to Ms. Jeffers.
Yes, Your Honor. Thank you. For the record, Megan Gilmore on behalf of the respondent non-moving party, namely James Kindle. I think that it is first I'll address the request to set over. And we weren't before Your Honor last week. However, I did provide information to Commissioner Nelson that the child, I believe the 14-year-old child in this case, attempted to commit in mother's home between the time that we had filed our responsive pleadings. I asked for a set over to allow us the opportunity to present medical records. I can inform the court that my client's still working on that, and I'm working with him to provide that information. In the interim, not only has mother filed a declaration, but then she has made contact with the guardian ad litem, who then subsequently had a unilateral interview with this 14-year-old child without notice to me or my client. So frankly, I don't think that either her additional information submitted within after the last hearing or the guardian ad litem is appropriate. Moreover, my client adamantly denies ever involving these children in conflict. And if anything, this guardian ad litem report filed on March 6, 2023 directly shows that mother is pushing this 14-year-old child to provide this information to the guardian ad litem, and the guardian ad litem is actively supporting mother's position and supporting her motion. So what you see here in this guardian ad litem report is that allegedly the petitioner contacted the guardian ad litem on March 1st, which is conveniently one day after last week's hearing, indicating that the child wanted to talk to the guardian ad litem. If you look to the statements of the child, she's not necessarily indicating that the issues have actually been resolved. She actually, frankly, makes the statement, I'm almost as big as him. He's not as much of a threat anymore. So the child clearly, beyond some convoluted conversations between while mother is present conveniently, manipulating the child, I would argue, the child is still acknowledging that there is some ongoing fear here. Again, this matter has been before the court several times. The court's very clear on the record. We've argued this at length. There's been multiple motions. Frankly, we went before the court in trial in 2020. At that point, the guardian ad litem testified to the court that Mr. Fuller had resolved his issues. And then frankly, that case was resolved. Mother then brought her own petition. Just months later, Mr. Fuller then was charged again with another 2 assaults against the child. Mother then, at the original investigation, testified to the police, and again, this is part of the record, that she acknowledged that domestic violence happened from Mr. Fuller to the children. Mother then took it upon herself, once Mr. Fuller was actually charged, to then testify under penalty of perjury by way of declaration in the criminal case that this then 12-year-old child was lying to the court. Mother was willing to lie to the court to the extent so significant that this child wasn't appointed an attorney because this 12-year-old child was facing criminal liability because her mother was frankly throwing her under the bus despite being the victim of domestic violence. Mother's actions have only further victimized these children in this case. And now Mr. Fuller has frankly pled guilty to the exact incident the mother claimed that, again, this 12-year-old child was lying for. Mr. Fuller is the last person that needs to be exposed to these children. These children have extremely fragile mental health. It's undisputed that this child attempted to commit literally last week or the week before. She was hospitalized, and the court needs more information before, again, exposing these children to their abuser. We do ask the court either appoint them attorney pursuant to RCWs or be willing to interview them. I think that I do have concerns, and I voiced this frankly throughout this case regarding bias. And I think that if anything regarding the guardian ad litem, I think this recent guardian ad litem just completely clarifies to this court that the guardian ad litem is willing to be adversarial and support mother's request, particularly to get Mr. Fuller into the home. So we asked the court to deny the request. I think that was very clear for the record. I would ask the court to consider attorney's fees, or frankly, if the court's going to grant the motion for contempt, I'd ask the court not enter into any fees whatsoever, because I don't believe that this motion was properly before the court. There's no substantial change of circumstance, and the court was very clear that this case needs to go to trial. So we do ask the court to deny the request for modification. As the court looking to the contempt, my client testifies in the declaration that he only recently lost his job. I think in the right in late 2022, counsel makes some sort of assertion that my client immediately quit his job after a child support order was entered. I would ask the court to look at the record. A child support order was entered in 2021. So my client only recently lost his job and was current on support until recently. He explains to the court in his declaration that he used all of his savings and his unemployment to pay a portion of a portion of the child support, which is frankly supported by mother's own exhibits. If you look to her exhibits, you can see that my client's making consistent proportional payments from unemployment as well as his own his savings. Frankly, if you look to December of 2022, my client made $793 in payments that is clearly coming from unemployment. Frankly, this is not a case that should be going before the court on a willful intentional violation. My client was very temporarily unemployed. He had an inability to pay, but he was making every attempt to pay. So this isn't someone that's stubbing their nose at a court's order. He's making partial payments, and frankly, he doesn't owe that much. And we frankly believe that this is premature and clearly not a willful intentional violation. Finally, looking to the uninsured medical cost, I don't think there's anything corroborating mother's alleged text messages. She's frankly drafting a text message that she then screenshots in one of her reply declarations. And again, this is information submitted in a reply that my client did not have the opportunity to respond to. However, there's nothing corroborating these alleged notices of uninsured medical costs with what's currently owing. What you see in the exhibit by mother is that she requested a summary of expenses on January 25th, 2023. She never provided any sort of notice of my client on what was actually owing, and then brought this action 5 days later. There's no sort of information before the court that my client was provided notice. So absent notice, my client acknowledges that he has an obligation to pay, and he's told this court that he's very willing to do so, as he's historically done, but I don't think that the court can find contempt absent notice. Finally, similarly, I believe the guardian letter can confirm this, following the order of the court in August, and again, this hasn't been a year and a half, the court entered in August, I believe in August or September, that my client was to take a psychological evaluation. Very shortly thereafter, my client made an appointment, but then at the time of the appointment, he became unemployed and couldn't take on the very exorbitant costs that the court can acknowledge within a psychological evaluation. He has subsequently, since re-entering employment, has made an appointment, and I can update the court that that is for March 21st at 9 a.m. Again, the order of the court provides no timeline in which this needs to be complete. Contempt is a high standard of the court, and it must be a black and white willful intentional violation. My client had no ability to keep a roof over his head while simultaneously paying his proportional, a good amount of child support, as well as paying, I believe, over $3,500 in a psychological evaluation. So absent a timeline and a very clear court's order and requiring him to do so, I don't believe the court can find contempt. So we ask the court deny the contempt, deny the request for fees, and deny the request for modification of the parenting plan.
You know, arguments by father kind of show this ongoing kind of pattern of dishonesty with the court. There's filed documentations regarding this alleged assault. There was never any 2 counts of assault against the children. That just never happened, as was just now disclosed. You know, additionally, father says, oh, I don't have the money, but he has been spending money like crazy. He says that, you know, he doesn't know about the medical expenses. He was at the hospital. The email, the text messages aren't just the summary that my client wrote for the court's sake, but it's text messages when these bills are coming in, and it's him not making any payments towards that whatsoever. Quite frankly, even what he represented to the court for continuance last week is that this was because of Mr. Fuller. Obviously, that's not true. The hospital paperwork was submitted, and we are talking about a young lady that has some pretty significant behavioral issues. She has been institutionalized for them. And it was a simple matter of her not doing her homework, not participating in school, and having her phone taken away. That is exactly what happened. That had nothing to do with Mr. Fuller. Mr. Fuller hasn't had any access to the children. And certainly what's also kind of disturbing is that father asked for this continuance and says, oh, you know, my daughter wants to say that it's not Mr. Fuller, that she doesn't want contact with Mr. Fuller. And then the next day, the daughter wants to have contact with somebody to say her side. Again, historically, if father's pattern is the same as it used to be, and the court has already made findings with regard to, he believed that she was going to say what he wanted her to say, and that ended up not being what happened. My client in her declaration indicated that she does not talk to the children about the case at all, and the children shouldn't even have known that this motion was before the court. If they do have knowledge, it came directly from father in an attempt to manipulate the situation. We are asking that, and I did look at the pleadings, Your Honor, although the provision with Mr. Fuller remained in place, it looks like it was father's motion. The issue with regard to I'm sorry, with regard to Mr. Fuller, that wasn't actually a motion that was before the court. On that day, the court addressed like, oh, okay, afterwards the order is going to stay the same. But the only motion before the court was to modify the parenting plan to a 50-50. And that's what the court discussed and then moved on. So we are asking for finding of contempt today and a modification of the temporary orders. Thank you, Your Honor.
There were several requests, I think, and potentially from both parties to refer back to prior GAL reports, just as I haven't heard this case. Several, but it clearly has been ongoing for quite some time. So I did review the prior GAL report and do note some concerns there. I'm gonna talk about the motion to amend at this point. I don't see a substantial change. I understand the concerns around the contact with the child with the guardian ad litem and that mother being present. I understand that, nobody being notified. So I acknowledge those concerns. I have significant concerns about a lot of things in this case. I'm concerned that on one hand, we have a reference to daughter being gasoline that helped Mr. Fuller, helped ignite Mr. Fuller. A 13-year-old is not responsible for an adult's actions. I don't care how they act. But now she knows what she wants and she's okay to say that she can have contact with him. So those kind of two issues don't match up to me and I have concerns. I don't see a significant change in the situation, and I am not going to amend the family law order at this point in time. As to the contempt, and Ms. Gilmore asked initially, and Ms. Jeffers did include it in her initial motion for contempt, listed the father ongoing shopping trips, vacations, new truck, new motorcycle, cell phone, guns. So she did refer to that in the initial motion in order to show cause for contempt regarding the child support payments and the back payments. I appreciate that Mr. Kindle used whatever unemployment he had to try to make up for those. And I also would acknowledge Ms. Gilmore's concern about one of the text messages does show the message and it's not sent yet, but there's also several other text messages that outline bills, and he affirmatively responds to some of those text messages. So I don't think that he can claim that he doesn't know about some of these medical expenses that took place with the daughter over the last, I'm going to say, year and a handful of months. Additionally, in the reply declaration from, the rebuttal declaration from Ms. Jeffers, there's a purchase of a vacation, 4 or 5 day vacation to Disneyland. I appreciate the family wanting to have time with one another and to do special things for the kids, but support has to always come first. So based on everything, I am going to make a finding of contempt based on the failure to pay support as ordered, given the fact that he clearly has money to do other things. I'm not going to make a finding of contempt as to the parental risk assessment. I am very aware that those are extremely costly, but I'm glad to hear that there's one scheduled for March 21st. My hope would be that there's no delay in that actually occurring and that that gets done and disseminated to the parties as previously ordered.
When it comes to DCS, typically what I've dealt with is that at least the amount owing, they don't like to enter additional judgment. I mean, if we can get some sort of documentation that's current, but typically they get a little hinky with DCS if you enter a judgment for the transfer amount. If we can get a confirmation, if the email attached exhibit is accurate on the uninsured medical costs, I think that it's appropriate to enter a judgment. As to attorney's fees, I previously made this argument that I think that both of the motions kind of balance out. I think that there was no substantial change. I think that we have ongoing concerns about manipulation. So I would just ask that the court either reserve or deny on fees for the contempt.
And Your Honor, sorry.
No, I just want to ask Ms. Gilmore, what you referred to something at the end of your argument about the judgment. being correct? And was that an attachment that I can see in Odyssey? And
I
if so-
believe that it was attached as an exhibit to one of Mother's declarations. It was an email from, I believe, DCS, just confirming the amount owing, and that's the one that I was referencing was 5 days prior to bringing the
It's an
motion. Email from Stacy Roper of DSHS. And it indicates that his share is $1,256.65.
Yes, and Your Honor, with regard to the judgment, it looks like we were kind of agreed. If Ms. Gilmore wants to verify the amount with regard to the medical expenses, with regard to the child support owed, we did show the most recent printout that we had of the amount owed. With regard to attorney fees, there's several bases here. I mean, he is not following the court orders. I mean, he's purchasing Disneyland tickets before he's even making sure that his children have appropriate resources for their daily needs. This has been going on for a long time since the child support order was entered, and Mother's finally had enough because she's bearing the full cost of these children, necessitating this motion. Additionally, she incurred additional attorney fees on having this case set over, and Father didn't even file anything. Thank you, Your Honor.
All right, so I think the medical expenses and back support, so that those fees are agreed. As far as attorney's fees, I will be the first to admit I'm stingy with granting those. I often just deny across the board attorney's fees. Normally I would do that. I mean, in this case, I'm going to award $500 of attorney's fees to mom on top of the uninsured medical expenses and past due child support.
And will there be any interest or due dates attached to that, Your Honor?
90 days, please, and then standard interest.
Thank you, Your Honor. I think Ms. Gilmore and I can send this to you off docket. Ms. Gilmore, do you agree?
Yeah, I think it's pretty simple.
So we're here
I
on
agree.
a motion to adjust.
All right,
child
good luck,
support.
everybody.
The
Thank
current
you.
order
Thank you, Your
requires the
Honor.
father to
Thank you,
pay
counsel.
$380 per month. This order was entered November 14th of 2016. The reason for my request is due to a change in income, and it's been over 6 years since child support has been changed. Dad's income is based on his 2022 W-2. He has not provided information showing that this includes overtime. Based on his current hourly wage, he averaged less than 40 hours per week in 2022, so his actual income should be used. Dad's gross income is $6,396 with a net income of $5,032. The standard calculation is $779. My income is based on my 2022 W-2, and deductions came from my year-end pay stub. My gross income is $4,238 with a net income of $3,475. The current order gives Dad a 21% deduction for the residential credit. I've included the same 21% deduction in my proposed orders. Based on the standard calculation and 21% deduction for the residential credit, the transfer payment should be $610. Case law makes it clear that there is no specific formula that the courts have to use to follow for a residential credit. If you review the current child support order and worksheets, the residential credit was lower than the credit shown on the attachment to the worksheets. Therefore, we should use the same 21% deduction for the residential credit.
Yes, thank you, Your Honor. Initially, I have a jurisdictional issue, support modifications, even when you look in the adjustment provisions under the statute requires a petition and a summons and service. We don't have that here. So I'm not sure that we have jurisdiction to do a modification of child support. I understand the original order talks about an adjustment, but as indicated, when you look at the forms that are required for a modification, it indicates that someone's in a petition, and you can then do this motion to adjust based on the summons and petition and after the client has the opportunity to respond. Beyond that, if you get to the substance of this motion, my client, there is no provision that I'm aware of that says if you do a 21% reduction at one point, you do the same thing later on. And the 21% is based on numbers that the petitioner has pulled out of the documents. It depends on if you use what was supposed to be the order of support. Then there were some adjustments made And depending on which of those numbers you pick, it was either a 21% reduction or it was a 29% reduction. Based on the math that I've done, but all that aside, the issue that is not being addressed here is the residential credit my client has with his son. He has his son a significant amount of time. And I think the, potentially the 21% or the reduction that they were looking at the last time had to do with a specific 90 days. And as indicated in my client's declaration, he has his son no less than 125. And we've taken that number, the 125, and we've plugged it into support calc, the residential credit formula that support calc provides. And it comes up with the support that my client should be paying based on the incomes of the parties. And I think the parties were pretty close on the income figures, but we came up with $450 per month support, which is an increase from what my client's paying. And given that the substantial amount of time my client has with his son, the overnights, the substantial events that my client is taking him to, their son is heavy into basketball. Your Honor could look through the previous motions regarding that. And my client takes him to tournaments and has bought him a car and various other expenses. That's what we're asking, is that the court use the formula for residential credit and set his support now at $450 per month, which would be an increase from the last time we were here and setting support.
So as far as it being a petition, should be a petition for a modification, I do believe a motion for adjustment is appropriate, as we are only addressing child support and nothing further. I believe it's in the statute or RCW 2609-170 that, 175 that provides the information on filing for adjustment. So I think it's appropriate to do an adjustment versus a petition or modification. The prior child support order was based on the current parenting plan. Nothing in the parenting plan has changed. He still has the same amount of overnights. And I believe that was based on a formula of 130 days rather than the 90 days that Mr. Anagnostou states. And as far as the incomes, I think we did get somewhat similar, but Mr. Anagnostou is using box 1 of the W-2s, which indicates an income minus deductions that are pre-tax, such as healthcare spending account. Box 2 and 3 indicate the actual income. Therefore, box 2 and 3 should be used for gross income. Otherwise, those deductions basically would be a double deduction because they are used in 2A and 2B on the worksheets, extracurriculars and basketball events and costs of that. The current order states that we both pay 50% of the agreed extracurricular activities. That's something that I've complied with and will continue to do so. I just ask that child support be calculated based on the accurate incomes of both parties. I ask the court to adopt my worksheets and sign off on the child support order.
In the declaration affidavit that was filed by Mr. Anagnostou, Mr. Irwin indicates, looks like it's on page 2 of 3 of that declaration, that the tournament level basketball costs of trainers, uniforms, equipment, tournament signups, transportation, and other miscellaneous expenses are paid by the father. Are you indicating that that's not accurate, that you pay for half of those?
That is not accurate. Yes, I pay for half of those, being that there's a bill exchanged and that they are agreed upon extracurricular activities.
Specifically the vehicle tabs license. And it doesn't refer to insurance, so I'm not sure if that was already contemplated in the parenting plan, but you agree that he paid for the vehicle tabs and the license for your son for so he can get back and forth from tournaments, school, and practice.
As stated in my file declaration, the vehicle that he states was for those things. It was purchased when our son was 14 years old. Our son already has a small, I believe it's an S10 or something similar truck that is at the respondent's house. It has been known as the daily driver by the respondent. He has made all kinds of frivolous upgrades that are visible on the vehicle. Our son doesn't even drive yet. He hasn't taken any tests for driver's ed to work toward getting his license. This is something that the respondent took upon himself to do. And like I said, it's been known as his daily driver. As far as the insurance portion of that, I don't intend to insure the respondent's vehicle, as I'm going to have to add our son to our insurance policy as well, since he is a licensed driver or will be a licensed driver in our house.
Any further response to that, Mr. Anagnostou?
Yes, Your Honor. My client is here at the hearing and he can respond, and that's the kind of the problem with this coming on. By the way, it did with the motion and shortened time to get a response in, but he's present and he can tell you that he bought a car for his son. That was last year. His son was 14 last year and he's since turned 15, and he is in driver's training. He is driving the vehicle. They pull up he was explaining to me, they pull up during the exchanges at her house, at the petitioner's house. He's driving and he gets out of the car and walks in, and then my client takes over to drive the car home. So he's bought this vehicle for their son. I think he turns, I'm not sure what age, this month. And he's going to finish his driver training. He's in driver's training, and get his license and needs to be insured and all those things. And my client, bought this vehicle for him, and they did have to do some repairs to it. She indicates that these were kind of frivolous upgrades. That's what she calls them. The car needed repairs so that it would be roadworthy for my client's son to drive and for her son to drive, so that he has transportation. And you can hear from him. I mean, as indicated, he's here, but like I said, this has come on by way of motion. We get, one response, and then she brings this up in a reply, brings up his medical issues in a reply, and he can address all those things, to Your Honor.
I guess the one question I would have would be more towards Mr. Anagnostou, and that's, I didn't get a financial declaration. There isn't one in Odyssey, so if you filed one, I didn't see it. And Miss Wright's outlines wages $63.96 for Mr. and $42.38 for Miss. What was your initial numbers, I guess? Oh, I see that now. I'm sorry.
Yeah, our numbers. Let's see.
About a $600 difference about.
Right.
Okay. She actually has those included. So she has the under section 2 of the child support worksheet, A, B, D, all pretty much match.
Right.
She has 489 and not 437 for FICA, and she has 683 instead of 655 for income tax. She has the union dues as 192, which is the same as what you have, which results in about a $550, $600 difference on line 3.
Right. And those numbers would have come from support calc, which estimates your taxes, which kind of avoids the issue of refunds and those type of things.
Well, there's I think that obviously the amount of time necessary to request a change in child support has elapsed. So this is properly before the court, at least this time frame is considered. I understand Mr. Anagnostou's concerns for how it got here, but I think the court, I'm prepared to just move forward with it today. So I'm just comparing numbers on the different worksheets here. And I would agree with Mr. Anagnostou. I think a 21% doesn't mean 21%. It's the overnights, and we're basing those at 125 being the minimum. So the overnight credit would be for 125 nights out of the year. But I also so I'm going to make a deviation from both parties' requests. And I'm going to set support at $500 a month. I'm assuming his support already been paid for March.
I don't know.
I don't believe that it has. I think it comes out on the 1st and the 15th, maybe, or the 1st and the 20th.
Okay.
So we're starting this March 1st, Your Honor?
If it hasn't been paid, yes, let's start March 1, 2023. And then all other, so I'm going to enter the child support order that was presented by Ms. Wright. But I'm going to show the deviation, and I'm just going to set monthly support at 500, initial that. Everything else is remaining at 50%. So if there's any concerns with that, so proportional share, 50-50 on all agreed extracurriculars. So all that will remain the same. And I'm just going to change on the order as well. It says starting February 1. I'm going to just make that March 1. And then I'll also enter the order that approving a modification in child support. All right. Anything else?
No, thank you, Your Honor.
Nothing from us, Your Honor.
All right. Thank you. Good luck.
Thanks.